Defining IPR, we had seen that there are certain elements that together constitute the concept of intellectual property right. We saw the fact that the subject matter can be replicated, it can be repeated, the fact that the right grants the right holder the option of enforcing it against others, and we also saw other characteristics or traits of intellectual property right. Now, one of the things in understanding or in defining intellectual property right is to first understand the subject matter on which the intellectual property right will manifest itself on. Because as I said earlier, intellectual property rights are a group of rights which manifest on different expressions of ideas. That is one definition of it. It also manifests itself on the new rights are not actually on ideas, like a geographical indication is not actually on some idea. It's the fact that there are certain products that come out of a particular geography which are valuable, and it's an attribution to the origin from that place. That place may have certain special weather, or it could have some climatic conditions which makes the product or contributes. The geography contributes to the product, so you identify the product with a particular place. Now, there's not much idea involved.
Who will be the beneficiary of this geographical indication?
The beneficiary of a geographical indication, the people are the community which uses it, right? The producers from that place, they are the people who can use that right. For instance, Darjeeling tea. The people who are having plantations in Darjeeling and who are actually in the manufacturing and production of the tea, they can use that label to say that this tea is from Darjeeling. Because the Darjeeling tea, it has been found out that has certain properties which is not there for tree that is grown in Coorg or in some part of Sri Lanka. It's not there. So the people who are able to manufacture from that particular region can claim a GI, a geographical indication. Now, coming back to our definition. So, we know an intellectual property by the subject matter on which it manifests itself. If an idea manifests itself in the form of an invention, then that is protected by a patent. If the idea manifests itself in the form of an expression, a literary work or an artistic work or a cinematographic work, then that is protected by a copyright. If the idea is an aesthetic design, a design that pleases the eye with no functional component to it, it's just that it pleases the eye, then we say that subject matter can be protected by a registered design. Now, to understand a registered design, I'll give you this example. A shoe that is designed by a company like Nike or Adidas will have certain design elements which also contribute to the functionality. It makes it cut the air faster, it gives it grip, it gives certain support in certain parts of the foot. So, those design elements have also a functional component. So, we do not say such design should be the subject matter of a registered design, because there could be an aesthetic part to it, but if there is a functional part, right holders will not go for a registered design. Whereas, if a shoe is designed to look like a bunny or a rabbit, many children's shoes are designed like a rabbit or like a character in a cartoon. In such cases, we don't say that that design has a functional element. We should try to understand the scope of a registered design is for things that are aesthetically pleasing to the eye, and the test is what the eye can see. So, when functional elements are tied to the design, right holders normally do not go and get a registered design for it. They have multiple rights. First, it's a trademark. Then the thing can also be copyrighted the way it looks, because almost all dictionary characters were at some point subject matters of copyright. So, you cannot create that image in any other form, and that violates a copyright. And copyright, as you know, it's the life of the author plus 60 years in India. So, it's quite a substantial right. In defining intellectual property, we first look at the subject matter. Then we look at the form by which it is protected. Now, we said that intellectual property rights are intangible rights, and it is sometimes difficult for us to ascertain the contours of this right, the boundaries of this right. Registration is a way in which we can understand what the right holder has claimed. Registration could be a registration of a patent specification by which a patent is granted. Registration could be registration of a literary work. Literary works can be registered, though it's not mandatory for enforcement purposes. Software code gets registered by way of a copyright. Trademarks are registered. So registration is the process by which these rights become quote unquote official. It's recognized, people can verify it, and it is also, because it is backed by a law, the Trademarks Act of 1999 is what gives the trademark holder a right to enforce it. The Patents Act 1970 gives the patent holder a right to enforce a granted patent against others. So registration is done by the government or by the state. So registration confers sanctity over the intellectual property right. So subject matter can vary, and depending on the subject matter you can have different rights. Type of registration, the details of registration also varies, because if you are filing a design, a registered design or a registered trademark, you are just filing forms and figures. You're just filing some papers with some marks in it, and the registry does a check, and the registry, if the check is cleared, then you get your right. It's more like matching what has gone before. Are there similar terms? Then the registry may raise an objection. If there are no similar terms, you invented or you coined a word for the first time, nobody else has done it before, most likely you will get the mark. It's a straightforward process. Design, again, the design looks unique, it's original, and you are the first person to file that design, it gets a registration. But patents follow a different path. The patent specification will have to explain in detail the entire invention. And it is not just the invention, the working of the invention, the features of the inventions, the advantages, the various variations in the invention, and the right holder will also have to explain what went before the invention. So it's a narrative. He explains his invention, and he also, before that, he explains the background of the invention. What were the technologies before him, and how it was not possible for a person skilled in the art, which is his peer, to come up with this invention, but he, with his inventive effort, was able to come up with it. So it's a narrative which starts with the background art, then it goes towards describing the invention, the purposes of the invention, what are the problems the invention solves, various other things, and it also has embodiments, illustration, how the invention works, or what are the parts of an invention, if the invention is a mechanical invention. And finally, it ends with the claims. So this entire process of explaining the invention, when it is captured in what we call a patent specification, the patent office does the job of not just registering it. It also scrutinizes the details in great depth. Now the scrutiny is done by giving a report to the right holder. In India we call it the first examination report. The first examination report is given where the right holder is asked how he can justify his invention in the light of, if there are any objections, but most likely there are. If there are any objections, either it could be technical objections or it could be some substantial objection. If the patent covers a subject matter which is not patentable under the Indian law, there will be an objection. If the patent covers something which has already preceded it in the art, it is preceded, it's already come, or the patent covers something which is obvious for everybody to do. In all these cases, the office is going to raise these substantial objections. And these substantial objections, it takes time to get over them. And this process of the office raising objections over a patent application is what you call patent prosecution. And patent prosecution is a very detailed and sometimes complicated process. Patent prosecution actually is different from a trademark prosecution or a design right prosecution, in the sense that there is quite a lot of details involved, there is quite a lot of analysis of what the person says, which goes into it before the right is granted. So registration is one of the key elements by which we can define intellectual property rights, and registration itself varies. Just how the subject matter varies when it comes to different types of intellectual property rights, the registration process also varies when it comes to different types of intellectual property rights. Then these rights offer a set of rights, intellectual property rights, be it patents, trademarks, copyright, designs. They offer a set of rights, it's actually a bundle of rights to the right holder. And these bundle of rights also varies. In the case of a literary work, the right may involve the right to print, the right to publish, the right to perform, film or record the subject matter. Because here is an expression of an idea, and all the forms of expression most likely which can be captured in a medium. This is critical when you understand copyright, because copyright is the right to make copies. And when you are talking about the right to make copies, where are you making those copies? There is always a medium, right? So before copyright came, I mean, this is just before the Industrial Revolution, the world followed a means of transmitting knowledge, what we commonly call the oral formulaic tradition. Now, if your children are studying nursery rhymes, which you studied and which probably your parents studied in school, that's because of the oral formulaic tradition. They are the same ones which gets repeated over the years. And this used to be just before, I mean, the Industrial Revolution, which is seen as a point in history where these rights came into being. They were, I would say, remote instances of rights even existing before that, some kings granting these rights, but the rights attained international recognition with the advent of the Industrial Revolution. There are reasons for that, historical reasons, we will get into it soon. So, before copyright actually came into existence, or before copyright became a recognizable right, there was the oral formulaic tradition. The oral formulaic tradition was a tradition by which people just memorized things and passed it on to the next generation. Now, if you do that, technically, are you violating a copyright? Because now the medium is your mind. You remember things in your mind and you pass it on to the next generation. And the next generation, or the person who hears from you, he or she remembers in her mind, memorizes it and passes it on. So the oral formulaic tradition, unless the substance is captured in some medium, can remain outside the purview of the copyright regime, because the copyright regime requires things to be recorded or expressed on some medium. So print, the medium is paper. If it is film, it's recorded on tapes, or now it's digital. So you will understand that whenever we are talking about making copies, it implies a medium being there. We don't say that if you heard somebody reciting a poem to you and if you memorized it, you don't say that I made a copy of it. You don't use that even in common parlance. We have different terms for that. We would just say that I memorized it or I learnt it by heart. So this is a critical point that you need to understand, and it has some history behind it, in the sense that copyright, when it evolved as a right, if you look behind it or before it, you will find that Europe especially had an oral formulaic tradition. And there are enough number of studies which, some of which say that one of the biggest beneficiaries of the oral formulaic tradition was Shakespeare. You know, just before Shakespeare came in, he actually inherited from a oral formulaic tradition. And there are studies which say that some of the things that he wrote were already there in the oral formulaic tradition. So that was a point in history where the right became recognized, and because of the Industrial Revolution, it spread far and wide. And the Industrial Revolution also contributed to it, because all the things that we were talking about, intellectual property rights, are first emanated in the Industrial Revolution. We said these rights are duplicable. You can make multiple, you can reproduce them. If you have the first copy, you can make multiple copies of it. Industrial Revolution actually mechanized manufacturing. It made producing many copies of products easier. Industrial Revolution gave value to things because they were manufactured in large numbers. An entire industry of marketing came with the Industrial Revolution. Before that, people were not marketing the way or the scale in which they were doing. This again is similar to what we discussed about intellectual property rights. We say that intellectual property rights are valuable rights. They are commercially valuable. And intellectual property right is tied to an idea which can be shared to others, or which can be expressed, or you can have an application out of it. If you just see the advent of industrial revolution, there are certain things that contributed to the growth of industrial revolution itself. One of the things include the advancement in printing technology. Now this led to the quick spread of ideas, because printing technology advanced and you could make copies of what was disseminated. Big ideas, great works could now be copied and it could be sent to other places. And because of the invention of steel and our ability to cross the seas using ships which could withstand long voyages, we also found that people were meeting each other or crossing borders at a much greater pace than they ever did in history, and at a much bigger number. And in Europe, this actually led to the need to translate works. So when you found a new German philosopher coming up with his work, or a German artist coming up with his work, you found quickly people translating them and that idea spreading in England. So when people started moving, that also contributed to them understanding each other, and the entire field of translation or interpreting other languages came up, which also led to the quick spread of ideas. So the reason why we take the Industrial Revolution as the point where intellectual property rights actually took off is it was tied to idea and it was tied to dissemination of ideas.